So
cool. Excellent.
Let's go with this and get this show on the road. Thank you those who have joined us. We are here for harassment in the workplace, addressing harassment and violence in the workplace. This presentation will be brought to you in partnership by our placement student named Paul, who is sitting here with us today. We will get into a little bit of introduction very shortly and who we are, SWEAC, the Sudbury Workers Education and Advocacy Center. And then we're going to just talk a little bit about ourselves and get into the presentation. So to tell you guys a little bit about who we are the Sudbury Workers Education and Advocacy Center. My name is TT Scott. I'm the communications officer here at the center. There are two others on our team. Scott, our executive director, and Mel, our client intake officer. And we pretty much drive for advocating for workers, making sure that they are informed on their rights, keeping them educated, keeping them supported through the process, giving them resources, and then advocating for them. So, showing up in rallies, giving them platforms so that way they have a voice, and that way their voice is shared through the media, shared through outlets, and heard, especially through this upcoming election that we have soon. So yes, we just want to make sure that workers are especially informed and especially able to advocate for themselves in the workplace and outside, and create a clean and healthy work environment that, is no longer subject to harassment and violence. So, addressing the things that we're here for today. So I'm going to move on a little bit and tell a little bit more about who we are. Some of our services are here on the screen, so you guys can, of course, visit us online. I will drop some links in the group.
TT, you have muted.
Sorry, as I go to share more things in the group chat. But you guys can keep in contact with us if you are interested in our phone-in, drop-in, pure one-on-one support services, or of course, just want to get involved in any advocacy or rallies that are happening here in Sudbury or the northern region. That's a little bit about who we are at SWEAC, the Sudbury Workers Education Advocacy Center. And I will pass it on to Paul, let him talk a little bit about who he is and why he is, sticking with us for this presentation and why we're here today.
Mm-hmm. First off, thank you so much for joining us. There's a lot of other things you could do with your Friday night, so thank you for spending it with us. We very much appreciate it. Also, just as a note, my computers, I have two screens. My webcam's on this screen. I got another thing on this screen over here. So if it looks like I'm looking at the camera and not looking at the camera, that's why. I've got notes and things over here. But anyways, I am a student studying at Laurentian. I am completing my final year of a Bachelor of Social Work program, and I'm doing my placement requirement at SWEAC. I have nothing but good things to say about SWEAC. They've been really great to me. Lots of education, lots of learning experiences that I've had personally, so I can't recommend them enough. And I currently work as a DSW for the company Christian Horizons. If for those of you who don't know what Christian Horizons do, they are a company that works with people with developmental disabilities to advocate for them and help them live their lives and things like that. So that's currently what I do for work. Further, we just want to do a quick land acknowledgement. We recognize and acknowledge that SWEAC is located on the traditional lands of the Atikameksheng, Anishnaabeg, and that of the greater city of Sudbury also includes the traditional lands of the Wahnapitae First Nation. We recognize that we do live in a colonial country and we have a colonial history. So it's very important to recognize and acknowledge that we are living on land that originally did not belong to us. And further, what you say in here stays in here. We can be talking about sometimes stressful issues or issues that can give people a lot of anxiety, possibly. Workplaces hopefully are not stressful and they don't have a lot of anxiety in them, or at least you hope that they don't, but sometimes it does. So what you say in this meeting, if you decide to say anything, if you decide to speak in the chat, it's completely confidential. It is going to stay here in this meeting.
And we just want to say on that too, if you choose to ask any questions, please ask them privately to the host and panelists privately. There's also the question box that you can choose. And if there are any confidential questions that you have, or, you know, personal issues that you want support on, please just contact us personally on we have all of our links below, and you can fill out a preliminary intake form. You know, even just send us an email, send us a call, and we can get back to you very shortly just to discuss that. But great going, Paul. I'll give it back to you there. Yes.
Okay, so actually, TT, so can the participants talk in the chat? Is that how this is that what they have?
Excuse me, sorry. They are able to respond in the chat, so we will be able to see the responses as long as it's hosts and panelists for you guys. So just make sure that is checked off, and yeah, just you can ask the questions away, or I can read them. But there you go.
Perfect. Well, so you know, I've told a little bit about myself, and so has TT. Tell us a little bit about yourself in the chat. What do you do for work? How did you hear about us? Why are you spending your Friday night with us instead of doing something else? Yeah, just anybody can respond. And of course, not obligated to. If you feel like kind of just listening in and staying quiet, that's fine too. But I'll give it a minute for anyone who wants to respond.
And if anybody wants to also jump in, you can easily respond by raising your hand, or simply just, you know, responding to the host and panelists. If you or someone you know has experienced violence and harassment in the workplace, and this can be a simple yes or no. This is just for our own, you know, research purposes, just to get a general idea of how many people are still experiencing this, especially if you are located here in Sudbury or the northern region or wherever you are. This just kind of gets us a general idea of who we're reaching out to, you know, what our impact is if you're a worker, if you're an employer, maybe you're somebody who's supporting a worker, just so we kind of know the idea. So yeah, so some people are saying learning, just getting an idea, learning more. That's great.
Okay, okay.
See, some people have more personal experiences. Yeah.
Interesting. Yeah, and so obviously with my placement, this is obviously a learning opportunity. So in actually putting this this presentation together and learning from TT and some of the other employees at SWEAC, I've also educated myself on a lot of these issues. I'm certainly not an expert, but I've definitely learned a lot. So even just putting on this presentation, I've certainly learned a lot more about like workplace bullying, harassment, things like that as well. So yeah, thank you so much for responding.
Aaron,
I really appreciate it.
That's great. So we hope you guys get something very good to take away from you. Either way, you will have fact sheets, links, and our connections at the end of the day to, you know, still talk to us, even just share your story if you want to, just to be like, hey, this is what happened to me. Do you think this is crappy too? And we can definitely be there to, you know, just support you through that, because so many situations are just generally just crappy. But let's get into the more elegant version of this presentation, and I'll give it back to Paul there.
Okay, so I think, and this was part of when TT was helping me design this presentation, that there is a difference that we kind of like to get out of the way first, so that we understand that there is a difference between harassment and interpersonal conflict. That you probably won't get along with everyone that you work with. Personalities will clash. They do clash. In some cases, it can just be inevitable. It is going to get, you know, personalities. You're not obligated to like everybody, and you probably won't like everybody. But there is a difference between not getting along with colleagues and being discriminated against, harassed, and bullied. And I can tell this from personal experience. I have worked with some people that I just straight up don't like, but you can still have a civil relationship with them and things like that. But depending on the situation, not getting along with a coworker may fall under a workplace policy. I know that where I work, they have extensive procedures and policies about how to resolve conflict and tension with people that are on your team. But there is a difference. Just because you don't get along with someone doesn't mean that they're harassing you or bullying you, or that you're harassing them or bullying them. But as always, if you're not sure about a situation, that is exactly what SWEAC is there for. Call and someone will help you. And if they can't help you, they'll point you in the direction of someone who can help you. That's exactly what SWEAC is for. Reprisals, another thing that we should kind of talk about and get out of the way. We'll get into the more detailed stuff later in the presentation, but there's a lot of rules and legislation around keeping you safe in the workplace, especially when it comes to discrimination, harassment, and bullying. And sometimes if you kind of stand your ground and you say, hey, this isn't right, this isn't good, this isn't safe, your boss will sometimes, he'll punish you, or maybe he threatens to fire you. Maybe he threatens to discipline you or suspend you. Maybe he threatens to dock you pay or intimidate you, coerce you, punish you, anything along those lines. If this sounds familiar, that's illegal. That under Ontario law, that is illegal, and it's called reprisal. They are not allowed to punish you in any way, shape, or form for standing your ground on your rights and the rules and legislation that keep you safe at work. However, in the very kind of specific times we're living now, this can be a little complicated. This can be a little complex with COVID. I don't know, like an example in my own life, this actually happened to me. Your boss switches your hours around to something that's very inconvenient to you. Now, if you are standing up for your rights and your boss switches your hours to something super inconvenient, that might be reprisal. But in my own workplace, especially considering that we're very close to healthcare, they split our hours all across the board, and we had very little contact with other people, and it was pretty inconvenient, but they were just following public health safety protocols. So it might be your boss, it might be reprisal, but it also just might be your boss following public health safety standards. It's hard to tell. Again, it's not on the slide, but if you're confused, SWEAC, they're there to help you sort out that kind of confusion. You can talk to somebody, you can call somebody. But yes, reprisal is illegal. But two, it can be a little confusing. Call us if you're confused. Okay, so let's get some definitions down just so that we know what we're talking about. First is harassment. Unwelcome comments or behaviors over time that are known to not be welcome or reasonably known to not be welcome. Serious one-time offenses can also be considered harassment, depending on what it is. But essentially, it's unwelcome comments that are known to be unwelcome. So if someone makes an offhanded comment once and they figure out, oh, that my fellow coworker doesn't like that, that's not necessarily harassment. It's when you keep on doing it. It's when there's a coworker or a supervisor keeps on making inappropriate comments that they know or have been made aware that they're not welcome, not appreciated. That's harassment. Bullying, very similar to harassment. It involves repeated incidents or a pattern of behavior that is intended to intimidate, offend, degrade, or humiliate a particular person or group of people. It can cause either physical or emotional harm and can include tactics such as verbal, nonverbal, psychological, and physical abuse or humiliation. Now, in legal terms, bullying tends to fall under harassment. Finding the specific word bullying in kind of like legal documents, you might not necessarily find it, but a lot of workplaces will have policies specific to bullying, and it will typically fall into, and they might have separate definitions between harassment and bullying. But in any case, bullying is absolutely something that is not acceptable, and there definitely are routes you can take for complaint processes, and of course we'll get into all that. But yes, bullying and harassment are, while similar, can be different, but it is important to get these definitions down. Violence in the workplace, a toxic work environment. This is something that I learned fairly recently that kind of surprised me, but I'm glad it's there. Harassment and bullying can involve any one of the following: workplace owners and employees, management and supervisors, employees and coworkers, customers and clients, family, spouses, and friends of workers, and any individual on the workplace property. So this is something that I learned while making this presentation. For example, let's say that there's an employee who's in a physically abusive relationship with a partner, and that partner shows up to the workplace. That now falls under harassment policy. That falls under that, like, bullying and harassment policy. The workplace actually has to care about that. That is not a separate issue. That is an issue that is included. That's something I didn't know about, but yes, that is something that falls under it. Yes, something I didn't know about.
And just to extend on there,
Yeah,
thank you, Paul, for that. That was amazing. But that also extends on to why it's so important for your employer to protect you from that toxic work environment, from harassment and bullying that you may experience in the workplace, that creates that notion where you're not welcomed. This environment is creating notions of just, conflict for you, so on and so on. All those things can amount to a notion or a workplace of a toxic workplace, or experiences of where you say, I've experienced harassment, I've experienced bullying. And it may simply just be on that one-off stance. They don't necessarily have to be repeated. It can be an extreme circumstance where it's like, it was just one circumstance that was very extreme, that still considers harassment and bullying and extends on to that toxic work environment. And we're going to get into a little discussion more about how to, go about dealing with these situations. We also don't have a slide exactly defining on what involves into creating that toxic work environment, but it doesn't have to be linked on to anything in particular. This can just be from, maybe somebody in the workplace that is constantly creating a notion that is generally making you feel uninvited, unwelcomed, threatened, in conflict, constantly nervous, constantly on edge. They're just necessarily maybe constantly giving that presence in the workplace that makes it toxic to be around. Maybe it could be your employer, maybe they're sending emails, maybe they're constantly complimenting you and you're saying, that's not appropriate, I don't appreciate that, so on and so on. So all those things can lead into harassment and bullying and creating that toxic environment, and don't, and fall into that early stages of where we're defining here, where everybody can be involved. So I'll go back to Paul to clean it up there and move on to the next slide. But that is just to give it a little definition on what we're talking about when we're, outlining a toxic work environment exactly, and the circumstances that you might be in.
Absolutely, thank you. Yeah, just like a toxic work environment is actually much more broader than you might think. So, really, like, ask us about it, because we'll definitely help you out. Okay, one further definition, discrimination. Discrimination is defined as treating someone differently based on stereotypical categories rather than their unique individual characteristics. So examples might include race, ethnicity, gender, sexual orientation, religion, disability, and more. We're going to get into some specifics about what falls under discrimination and what falls under harassment and bullying, because sometimes they can literally look identical but be different, and how they're handled is different. But this is the definition: to treat somebody differently based on those stereotypical categories such as race, ethnicity, etc. So your rights at work. In Ontario, how are your rights protected in the workplace? And there is a wealth of legislation that actually sets out a framework and standards for how you should be treated at work and to keep you safe at work. And that's what we're going to talk about. That's going to be the bulk of what we're going to talk about this evening. For example, there's the Ontario Health and Safety Act. There's the Ontario Human Rights Commission and the Ministry of Labor, and we'll get into more specifics, but these are all different pieces of legislation to make sure that you are safe and to help you be safe in the workplace.
And when we're also, thank you, Paul, for that. When we're pointing out these legislative pieces, we also want to highlight how the Occupational Health and Safety Act is funded and imparted under the Ministry of Labor. That gives its backing. That's where you're going to take your claims, your complaints, and so on, which Paul is going to get into much later. And just a brief discussion on, I believe Paul talks about on the separation between federal workers So I'll just say,
Yes.
okay, so I won't even talk on it. I'll let him speak on it.
But thank you very much. Yeah, we will talk a little bit about that. There is a bit of a jurisdictional divide. But in any case, the Ontario Health and Safety Act, what is it? It is a piece of legislation that sets a legal framework to keep workers safe. It literally sets out the rules and the regulations and the standards that keep you safe at work, that employers have to follow. Where does it apply? It applies to most workers, supervisors, employers, and workplaces in Ontario. And by most, I mean like the vast majority. Like there's not a lot of exceptions. There are some, but there's not a lot of exceptions. If you're working in Ontario, Ontario Health and Safety Act is going to apply to you. But where does it not apply? It does not apply to federal jobs such as post offices or airlines. This doesn't mean that they aren't protected or that they're not safe or that you do happen to work for an airline or a post office that you are not protected. It falls under a different piece of legislation. It falls under federal legislation as opposed to provincial Ontario legislation. It also does not apply to certain jobs specifically with the right to refuse work. So under the Ontario Health and Safety Act, one of the big parts of the safety is that you have the right to refuse unsafe work. That if you are, let's say that you're working on a piece of equipment, the piece of equipment is faulty, you don't have proper training, you don't have proper, there's no proper guards or whatever, you have the right to refuse unsafe work. We're not specifically going to be talking about that this evening, but police officers, firefighters, hospital workers, and certain jobs in the criminal justice system, there is a certain element of danger that is a part of the job. So a police officer, like a firefighter, can't stand in front of a burning building and say, hey, that's not safe, I refuse to do this. It's a part of the job. So Ontario legislation doesn't apply to certain jobs. But again, usually, doesn't apply to most people. The Ontario Health and Safety Act is going to apply. Okay, so with the Ontario Health and Safety Act, there's a complaint process, policy, and procedure. So you can file a complaint under the Ontario Health and Safety Act if you believe conditions in a workplace are unsafe, or if you or someone else is experiencing harassment or violence on the job. But before you report your situation, you can discuss your concerns with your supervisor or employer. You can consult your joint health and safety committee member or health and safety representatives if there is one. So this is actually super important because a lot of companies will actually have concerns. They'll have policies, they'll have procedures. In my workplace, Christian Horizons, it's a nonprofit, it's a pretty big organization. They have extensive policies and procedures for hazards in the workplace. And they're working with people with complicated health problems, especially during COVID. There are a lot of procedures and policies that we have to follow all the time. It can be a little overwhelming sometimes, but absolutely, discuss your concerns with your supervisor or employer. A lot of places will have policies and procedures to follow when it comes to harassment policy or violence on the job. That's, you're going to be your first resource. In the case of workplace harassment, your employer must do an investigation appropriate to the circumstances. Now, this can be really short, taking a couple of hours or days, or up to 3 months or longer. Again, it depends on the severity of the harassment or the violence in the workplace. But again, by law, they have to do an investigation. It's something that they have to do. They have to have policy for this. So again, looking at going to your employer and voicing your concerns to them, that's typically the first place you're going to go. But if you still feel that the situation has not been resolved after talking to your employer or your health and safety committee, you can file a complaint with the ministry. And that's, file with the ministry. Filing a complaint, the easiest way to file a complaint is online. Now, I didn't put it on this slide, but literally I Googled OHSA complaint and it was the first hit. So if you have access to a computer and if you have access to Google, the internet, this was not hard to find. Of course, there will be links that we will provide, but also this is pretty easy to find. And this is actually, this is a screenshot that I took from my computer. So this is literally what it looks like. The complaint form will ask for detailed information. Give as much information as you can and take the time that you need to fill it out. The more detail that you can provide, the better. We'll talk about that also a little bit later, but detail. It really helps in any kind of complaint process, that whenever you take an action, giving as much information as you possibly can it will never hurt you. It'll always be a good thing. If you don't have access to a computer or don't have access to the internet, but you do have access to a phone, you can also speak to a health and safety representative over the phone at the number that is listed on the screen. Excuse me. Okay, so with a workplace investigation, specifically under the Ontario Health and Safety Act, if the Ministry of Labour deems your complaint serious enough, they can send an inspector to your workplace. Like a literal inspector with the Ontario government can show up at your workplace and do an investigation. But there are some things that they will do and some things that they will not do. Examples of things that they will do: they will take every precaution to make sure that you remain anonymous. That if you are the one who made the complaint, they will actively try to make sure that you don't get found out. They'll also contact management, and they'll contact a worker representative to get more details, to get more information. And they will also inspect the nature of the complaint and address any hazards or rules that are broken in the workplace. So essentially, they're just going to step into the workplace and see if there are hazards, see if there are any problems, and see if any rules are being broken. You know, pretty straightforward, pretty standard. However, a workplace investigator will not resolve specific complaints of harassment. That is not what they're there to do. They do investigate, they will not investigate harassment complaints to determine if it was in fact harassment under the OHSA. So essentially that's not their job. When they show up, they're not there to like mediate. They're not there to be, you know, a middleman between two competing parties to figure out if something actually was harassment. They're not going to like that last point, they're not going to order individual remedies. They're not going to do financial compensation or extra vacation day. That's not what they're there to do. That's not what an investigator will show up to do. So they're not going to do any of that kind of stuff. The previous slide, they're going to show up, they're just going to inspect the workplace, make sure that the rules are being followed, and if any rules are broken, to make sure that they get fixed, and so on and so forth. But these are things that they are not going to do.
Just to throw on there, thank you for that, Paul. One of the things that the investigation will in fact do is after the after the investigation is over, they will contact you, they will let you know what's going on, they will keep you informed throughout the process, and they will have a pretty much result of what should be done as a result moving forward. So if you don't like it, you can appeal, you can move forward with the, typically most people don't like it, that the result might be there is no harassment going on, there's no violence going on, and that may simply be the employer is following the policy correctly. You don't have to, there's no violations occurring here, and there may not be any resulting like that. But there might be a result where they say, the findings show that the policy needs more work, so on and so on, and they may have to do more cultural bias training, and they may recommend more things like that. So you won't see like a direct compensation package directly to you, dealing under the Occupational Health and Safety Act, which is a little bit discrediting, and sometimes when you're going through these experiences, it can be a little bit discouraging, but it is still an option, and there are still ways to get you the justice and get you the compensation and get you the ways that you can move on, so that, and the support that you can move on, the resources and so on, so that way you don't feel like you kind of got the burnt end of the stick and you didn't get the justice that you deserved. Thank you again, Paul. I'll keep it going there. Yes.
Yeah. Well, thank you very much for throwing in there. So that is very true in the sense that there are further actions you can take. But with workplace investigations, like this slide says, if you file a workplace complaint, the most that an inspector can do is make sure that your employer and employees are following their harassment policy. And again, you might maybe the employer is just faking it for the sake of the inspection. This is not a perfect system, but these investigations do happen, and they will investigate complaints. But again, like TT said, you can appeal a claim, the results of a report or the results of investigation you can appeal. And again, SWEAC is absolutely there to help you. Like the slide says, to do any other kind of further investigation would risk letting the employer know who made the complaint, and further, as much as they try to preserve your anonymity to make sure that you are anonymous and that nobody knows who made the complaint. It's not always guaranteed. Sometimes the employer or your fellow coworkers they'll just like, see, there's the person who's rocking the boat. There's the person who's standing up for their rights. We know who made the complaint. They can't guarantee that that won't happen. So with workplace investigations, again, there are limits to how far they can go or how effective they can be, but they do happen and it is an option. And I will throw this over to TT, who is much more knowledgeable on these, the 3 pillars.
So now that we're getting into this deeper discussion of the Occupational Health and Safety Act and where it kind of ends here of, how far it can go on, for the result on employers and kind of making or amending them to do something right. So, they can make sure that they're following their policy that they've already laid out. And if they seem that their policy is not well made enough, doesn't follow the actual health and safety guidelines put out by the Occupational Health and Safety Act, then they'll tell them to reinforce it. But it has to be within that realm of harassment and bullying, and where it's that general idea of you're experiencing that in the workplace. But when it stems down into a larger issue and you're finally dealing with issues that are human rights violations, such as sex, gender, religion, race, ethnicity, so on and so on, ability, that is where it starts to become a Ontario Human Rights Commission issue, and it's going to be dealt with through the Ontario Human Rights System. So you might go through a claim process, so on and so on. So this talks a bit about the system that kind of revolves around it and how it's enforced, how it's kind of, I would say, built in a way. So to get a general idea, you have the Ontario Human Rights Commission itself. This stands at the top to develop the ideas and the policies that you hear. These are the different, measures, the monitoring, public education records and institutions that you're able to access. So the ability for us to share this information with you guys today, this is where you're going to get those amendments, those like new new constitutions, new deals, things like that, new codes. This is where they're going to come forward to you. And then you have the Ontario or the Human Rights Legal Support Center. This is where policies are going to be dealt with. So you might bring your actual claim to the Legal Support Center. You might actually get support through that process. You're going to get ideas of how to move forward next, how to deal with your claim. If it's an actual human rights issue, what the Ontario Human Rights Tribunal is possibly going to respond to it. This is going to be there to support you through that process. Then finally, you have the Human Rights Tribunal of Ontario. This is the big boy at the top. This is what's going to deal with the final claim, the final issue, the final decision. These guys are the decision makers at the end of your process, your your appeal, whatever it is that you're going through. These are the guys that are going to give you your final decision. Of course, you may be able to appeal beyond there, but these guys are still going to give you your final ultimate decision. So it becomes kind of scary for some people, but most people that are going to the Ontario Human Rights Board with their issues, they're going to go into their favor, because that issue is typically something that they've been going through. It's hard to unviolate. And also going into the Ontario Human Rights Commission itself, it doesn't move to try to get the employer to say that they necessarily did wrong. It's moves to, or it's for you to say that, to justify yourself, like this happened to you. All it tries to do is say that this is something that could have happened, definitely, because there are not enough policies in place, or the policies are not strong enough, so on and so on. So when the decision is ultimately made, is a policy going to get into how this is made and how it's a remedial decision, but this kind of just talks about how it's it doesn't really put anybody to fault. Nobody's going to be criminalized because it's civil. So all the issues here are going to be kind of dealt with in a lighter way. You might be compensated with monetary cash. You might be compensated with time off. You might be compensated with an apology letter, a public list. So it might look different for each person, but the Ontario Human Rights pillar in itself, this is, I guess, how it's constructed and how it reacts with throughout the public. So a little bit about that. I'll throw it back to Paul here.
Excellent. Thank you so much. So we are going to get into more specifics here with the Ontario Human Rights Commission. TT already did a little bit of explaining it, but this is going to be more detailed. So what is it? It sets a legal framework for people to be treated equally in society, regardless of different specified or specific grounds. And there are 17 different protected grounds that the OHRC covers. So again, this will deal more with discrimination rather than harassment and bullying. And again, talk about that as well. So where does it apply? It applies to people in Ontario in 5 areas and 17 grounds, which I mentioned. And I think these are actually important to go through. So the 5 areas that it covers are employment, accommodation, goods, services and facilities, contracts, and membership in trade and vocational associations. And grounds, and these are the important ones, grounds include citizenship, race, place of origin, ethnic origin, color, ancestry, disability, age, creed, sex/pregnancy, family status, marital status, sexual orientation, gender identity, gender expression, receipt of public assistance in housing, and record of offenses. So if you feel that you are being discriminated against, that they're treating you differently, it has to fall under one of these grounds in order to it needs to fall under one of these grounds in order to come under the legal framework of the Ontario Human Rights Commission. So, and this is where we get into the complicated, maybe like kind of blurry differences between harassment and bullying. But these are, it's a very, very extensive document that outlines what areas are protected and what you can't discriminate against. Okay, so where does it not apply? Actually, I already kind of mentioned it. So it does not apply if harassment or discrimination does not fall under one of the protected grounds. So if you, if there is somebody at work who's bullying you, but they're not bullying you for any one of those grounds, then that's not considered discrimination. If they're just, if there's a personality clash and someone is just, saying mean things to you because they don't like you, that's not discrimination. However, if a coworker is saying something to you and being mean to you because you identify as a woman, or because you are Sikh, or because you identify as a homosexual, that's discrimination. Those are protected grounds. You cannot do that based on those grounds, and then that would fall under this piece of legislation. However, there are specific exceptions. So, for example, age is a protected ground. So if someone is, if you're hiring somebody for a job, age is not something that you consider under employment. If you're hiring somebody, it doesn't matter if they're 18 or if they're 50, that shouldn't matter when you're hiring somebody. However, insurance companies are allowed to give different rates based on age. So there are specific instances and circumstances where companies are allowed to discriminate based on things like age. There aren't a lot of exceptions, and I had a hard time finding exceptions, but I literally pulled this example from the Government of Ontario website. This is one exception to the OHRC. Yep, that's the right one. Okay, so the OHRC discrimination policy standards. So under the Ontario Human Rights Code, employers, service providers, and housing providers have the ultimate responsibility for ensuring a healthy and inclusive environment and for preventing and addressing discrimination and harassment. This essentially means that an organization is ultimately responsible. They are the ones that have to deal with preventing discrimination and harassment in their workplace. That is not the government's responsibility, is an employer's responsibility. They have to do it. And an organization can be held responsible if discrimination happens on its watch. For example, it is held responsible if one of its employees, agents, officials, etc., engage in discrimination during the course of their employment. So if you have an employer or a boss and you have an employee on the bottom, and this employee is acting in a discriminatory way, the government can hold the organization responsible. So this is very serious stuff. They can hold them responsible, which is why organizations themselves have to have discrimination policy, procedure, etc. And I think we're going to talk about that on the next slide. Yes, yes, we are. Okay, so organizations are required to have a discrimination complaint process. It is legally required. If you think that you are facing discrimination in the workplace, your place of employment has to have a complaint process. And at minimum, and I copy pasted this. I took out some of the legalese to make it a little bit more easier to understand, but this is copy pasted from the Ontario government website. Complaints must be taken seriously. They must be acted upon promptly when received, and appropriate resources must be given to deal with complaints, which basically means that you can't just say like, oh, well, whatever, we'll just kind of put this on the back burner for a bit. It's like, no, you have to put an appropriate amount of effort into figuring this out. You can't just leave it. You can't just put minimum effort into it. You have to deal with this. And the company must have a way to receive complaints and have this process be known by the organization. You can't have a complaint process that's, given to Jim in the corner office that nobody ever talks to and nobody ever sees. You need to have this complaint process be known by the organization. It has to be known so that it can't just be ignored, that if discrimination is happening, you know where to go. The complaint procedure must be done in such a way that the person bringing the complaint forward feels safe to do so. This is more of an ideal rather than a command, because the problem with toxic work environments and discriminatory work environments. But ideally, bringing the complaint forward doesn't make the situation worse. That by bringing the complaint forward, the situation hopefully gets better and you can resolve whatever issue that you have, but ultimately that they feel safe to do so, that discrimination complaints don't make the situation worse is what they're going for. And decisions and actions taken by the organization must be communicated to the parties. This is something that TT mentioned earlier, that essentially that if you've got a person who brings forward a complaint and a person that the complaint is brought against, they both have to be informed of what's going on and how the investigation process or the complaint process is going. You have to be kept aware. So these are just the minimums. Organizations can go above and beyond these, but these are the minimums that have to be in place. So, like it was said, an organization must take steps to investigate a human rights violation complaint. And in the investigation, the investigator that is chosen must be independent and objective. By independent, they essentially mean ideally someone who is separated from the incidents, that the investigator can't be the person who is the discrimination complaint is for. Like that would make that obviously wouldn't be independent. That person would be a huge conflict of interest. Has to be somebody else. Wherever possible, the investigator should not be a person in authority over the people involved, because this also presents a conflict of interest, that if it's a supervisor who's dealing with it and there's two employees that are dealing with a complaint, the supervisor might prefer one employee over another, and that creates a conflict of interest as well. The investigation of the complainant must be impartial, timely, fair, and address all relevant issues. So essentially, the investigator, whoever is doing it, they should do it well. They should do a good job. They should, try to get all the facts. They should do it in a good time. They should be fair. They should try and address all of the issues that are relevant. There's basically just do a good job. In most cases, investigations begin immediately after an investigation is chosen, and it has a fixed time frame. I think in my the example they gave on the document was 90 days as an example. I think for my organization, I think it's 60. I can't remember for the exact number, but usually there's a fixed time frame that you have an investigator, it's chosen, it begins immediately, and then you have a fixed time limit where the investigation needs to conclude by. And different organizations will have different time limits and different policies, but generally speaking, it'll follow these guidelines. Okay, so let's say that you bring forth a discrimination complaint, you bring it towards your employer, an investigation happens. What actually happens with this investigation? So based on the investigation outcomes, a decision must be made about whether the complaint is well-founded, which is essentially to say that did discrimination happen? Is it reasonable to conclude that it happened or that it could have happened? If it is well-founded, the organization must make steps to prevent it from happening again. So they basically just have to try and prevent it from happening in the future. Human rights laws are remedial, not punitive. And honestly, those are just kind of big words. And they just mean that they're meant to remedy the situation rather than punish the person who did the discriminating. Because honestly, discrimination might not actually happen intentionally. While I was looking through this presentation, I actually encountered an example from my education, from doing my social work stuff. There was a school board, and there was a Latino community in the local area, and the Latino community wasn't showing up at the PTA meetings for some reason. And they were really confused. But it turned out that the Latino community in that area, all of them worked night shift. So the PTA meetings were scheduled at 4 o'clock right after school ended. So none of the Latino community could show up to PTA meetings. So they weren't obviously targeting the Latino community. They were it was a policy that affected a specific group of people, namely Latino people. And thus that policy was discriminatory. The solution was that they ended up holding PTA meetings in the evening and in the morning before school, because if they hold it in the evening, they were either at work or they were sleeping. So human rights laws are not about making sure that that school board really gets hit, because ultimately they weren't the enemy. They weren't doing something that they were trying to hurt somebody. It just happened to be that their policy affected Latino people, and they fixed it. And that's what human rights laws are trying to achieve. They're not trying to punish everybody. They're just trying to make the situation remedied so that the person who's discriminated against, or the group of people who are discriminated against, feel whole again, in a sense, that they feel that they're accommodated. So again, these are some of the potential investigation outcomes.
And then just to jump on there,
Go for it.
On that last point there, where you were saying how human rights laws are remedial and not punitive, great examples there too. I'll just add on, if you are experiencing something where, you know, you realize, okay, well, my experience of bullying harassment is, you know, discriminatory, it's under the human rights violation, but it goes beyond the civil legislation and what they can actually deal with, and you need to, you know, contact the police. Make sure you are documenting. We're going to get into that later still. Many of these things can still apply to your situation. If you know somebody else who is being pointed out physically, experiencing maybe possibly what leads on to be a hate crime, then they do need to contact the police or contact legal aid to go forward with those supports and those resources, because it's under a different jurisdiction. And you know, we just want to make sure you're getting the support and the aid and resources that are particular to your specific situation. So if you or anybody you know are experiencing that situation, please, you know, reach out to the resources that are most appropriate to that area. Just to add on there. But thank you, Paul. I'll throw it back to you again.
Yes, thank you very much for giving that information. That's very helpful. Okay, so the Human Rights Tribunal of Ontario, this is something that TT also briefly mentioned before. The HRTO, excuse me, tries to resolve claims of discrimination and harassment brought under the Human Rights Code in a fair, just, and timely way. And again, this is pulled directly from the Ontario website. If you believe that you have experienced discrimination or harassment, you can file an application with the HRTO. They will consider your claim if it falls under the scope of the Human Rights Code. So essentially what this means is that we've talked a little bit about the difference between harassment and discrimination. Essentially, if you file a claim with them saying that your coworker is being mean to you because, you know, I don't know, they don't like the smell of your lunch when you bring it in at work, they're not going to look at this claim, right? However, if you have discrimination, like they're bullying you because of your gender, then yes, that is something that they will consider. It just has to fall under those grounds that we talked about earlier. They will not consider your claim if the events are not connected to Ontario. So again, this does sort of apply to, I put it in the second point there about federal. If something falls under federal lines, or there are very unique circumstances where if discrimination crosses boundaries between provinces, then that's not something the Human Rights Tribunal of Ontario will cover. And so some examples they give is if the respondent is an organization or company that operates federally or between provinces, such as banks, airlines, television stations, bus or railway companies, this is something that Human Rights Tribunal of Ontario won't cover, because again, it falls, the jurisdiction of Ontario, if it falls between provinces, then that's a separate thing. That's a different issue. But this is, if, you know, if you truly believe that you're being discriminated against, these are people that you absolutely can go to. You can file a claim with them, and you can, there's ways to, and again, you can talk to SWEAC about more information, but this is an absolutely a route you can take if you're being discriminated against in the workplace.
And I'll just throw on there too, one of the other areas that you'll find exempted from this, support, and as recent laws have been changing, if you're a part of a union, if you're a union member, you are encouraged to reach out to your union reps. This goes for Occupational Health and Safety Act complaints as well. You are still encouraged to reach out to your rep, and they will not deal with claims from unions. So you recently, actually, for changes for the Human Rights Tribunal, they are suddenly not dealing with claims from unions, as if we are seeing that bill becoming put in place. So that is just something to keep in mind as a reminder, if that is your situation. And many more workers are being involved in unions now, and there are some limitations. Not that unions are not great, they are amazing, and they offer many benefits and new resources and opportunities for workers, but there are still limitations through that process. But still, there are resources and different options to give you support and make sure that you are, not stuck in a situation where you are just experiencing harassment, violence, etc., and you feel like there's no help. So yeah, that was just to add on to there. Great job, Paul. And I'll keep talking again because I'll take this slide here, which is just about what about competing rights? So when you get into a situation where maybe you had a human rights violation, but let's say the other individual feels like, they were fighting for their freedom of speech, so on and so on. So this is where we have competing human rights. It's a situation where the enjoyment of one individual's or group's legally protected human rights might interfere with another's. We've seen this a lot recently with COVID coming up and the pandemic. Many individuals were saying it was a construct on their personal freedoms with wearing the mask and so on, and with different occupational health and safety measures that have had to be put in place in workplaces. Thanks to the changes into the Human Rights Tribunal and the Human Rights Commission, they were enforced that it was not actually discriminatory and, backed by that. But you'll see either decisions come like that, or decisions ultimately be made on this working process or 3-stage framework where, it goes from recognizing the human rights, reconciling the rights and the individuals whose rights were violated, and making decisions that allow both individuals to move forward in a matter where they feel like they're no longer being interfered upon. They can move forward, and they're no longer stuck where they feel like there's a conflict. One thing is important, it's very important to remember that human rights are granted these special protections over other laws and legislations. So the second that it becomes a human rights amendment or enforced by the Human Rights Commission, it is instantly given a certain amount of, I guess, respect and entitlement, especially in the court legal rooms. So you are given that support when you're submitting these claims, when you're pushing through with these issues, because they're already such a serious violation. But that 3-stage framework, so you guys can understand it for yourselves, how it kind of works through is, first you start with recognizing rights. So that means understanding what the claims are. Are they both actually human rights issues? Then yes, if they're both identified as human rights issues, then the next step is reconciling rights. So that means, what is the next step to make sure that we can get a solution that is ideal for both individuals that have these claims that are both identified as human rights? So what is the next step to reduce the interference, reduce the conflict, and get them into a position where they feel like they can move on? Once that process, it might take months, it might take years, but once they go through that process, the next process is making a decision. So that means they consider the context of each claim, and then they try to come with an outcome that's not going to take away from anybody more than the other. In some situations, somebody might feel like they are, hit a little bit more than the other, because that's just the scenario. That's typically what happens. But when you're bringing it to the Human Rights Board or the Human Rights Tribunal, they're necessarily going to try to make a decision that will hopefully work in the benefit of both individuals and not take away from each individual who are, trying to, fight for their rights or simply just have their human rights respected. So that's a three-stage framework where if you ever come into conflict or another situation where, they say, well, I was just, fighting for my human rights, there are situations where it's like, were you, or were you just being mean? And, you're not entitled to, just be mean and just to bully people and have rude comments. There are situations where people think that they're just entitled to the freedom of speech, and it's very obvious that you're not. But with more serious issues that are, yes, this is clearly two human rights violations that come into conflict, they are handled in a more serious and clear process, so that way you don't feel like anybody is stuck or left out. And I'll throw it back to Paul here. Sorry, there you go.
Yeah, okay, thank you very much. That was a really great explanation. So we've been kind of dancing around this slide for a lot of the presentation. Also, I did see the question in the chat. Thank you so much for asking. It's such a good question. We will try to address questions at the end. TT is much more knowledgeable than I am, but we'll definitely give it our best shot. But yes, there will be an opportunity at the end. So we've been kind of dancing around this slide for a little bit. The difference between the Ontario Health and Safety Act and the Ontario Human Rights Commission and what they cover, and we've given examples kind of throughout the presentation, but the OHSA gives a legal framework for workers to be safe in the workplace, including bullying and harassment. And the OHRC is about treating people equally, regardless of their race, ethnicity, creed, gender expression, etc., or any of the other 17 grounds that we discussed. But this can be blurry. It can create blurry lines in the workplace about what exactly is covered. So for example, if an employee is bullying you or other employees creating a toxic work environment, that would fall under the OHSA, the Ontario Health and Safety Act. That's considered harassment and bullying. However, if an employee is bullying you or other employees because of their race, gender, or disability, that would fall under the OHRC, the Ontario Human Rights Commission. So even they can look identical. Maybe you're bullying somebody, but as soon as you start bullying somebody under one of those protected grounds, different, it changes. And we've gone through them, these have different complaint processes and different kinds of investigations. So hopefully, over the course of this presentation, we kind of know the difference between the two. I know that I certainly kind of took some time to really kind of practice and really put them in their proper categories about what they cover and what they don't cover. But hopefully that's something that we've learned. But yes, those are the differences between the two. Okay, so what should you do? TT did mention this a little bit earlier, but regardless of whether you're making a complaint under the OHRC or the OHSA, document everything. If there is a 1% chance that you think something will be useful, document it, write it down, everything and everything. It's so helpful. The more information that you have, the easier it is to make a claim, the more of a case you can make. Document it all, your contract, your schedule, days and hours worked, pay stubs, sick notes, injuries or accidents, health and safety issues, disputes and complaints, harassment and discrimination, reprimands and warnings, HR policies, sick days you took, maybe even like communication between you and your supervisor, communication between you and your union, if you have one, communication between you and your health and safety rep. If you think that there is something that might be a little bit useful, write it down, document it. It'll never hurt you to have more information. Document everything. It makes it so much more easy, so much more helpful. If there's one thing you take away from this, if you're trying to make a claim or dealing with any kind of issue at work, document everything. Do it. Okay, so examples and case studies. Kind of using this is like, as much as this is like an exercise for myself as well as for the people who are participating. These are some examples and case studies that came from a previous presentation on a similar topic, but I found them very helpful. Robert has dwarfism. Ken laughs at him and teases him about his height. Ken is known for teasing Robert and no one else. Is this harassment and bullying? Or is this discrimination? I encourage you to, I encourage participants to say, give their answer in the chat, just what are your opinions? What are your thoughts? I'll give it a minute while I grab a drink here. And sometimes it's not immediately obvious. Sometimes it can be a little, yeah.
This one can be, it might be a little bit tricky because it could be a situation of both. As I was saying before, you might experience a situation where it's a discriminatory situation because, you're being bullied, you're being harassed, but it's based off of a human rights ground. So it would be considered discriminatory in that nation or in that notion, in that era. But that is a general, I guess I kind of gave the answer a little bit to that general idea, notion.
Mm-hmm. So specifically in this case, this would fall under discrimination. So he is specifically bullying, Ken is specifically bullying Robert about his height. So that is a protected ground. I think dwarfism falls under the disability ground. It might fall under other grounds, but that is a protected ground. So this would fall under discrimination. Here's another one. Janet, who is a supervisor, repeatedly makes less than appropriate comments towards all her workers, except a few whom she feels are her friends more than workers. Others feel, she gives special treatment to these friends. So again, repeatedly makes less than appropriate comments towards all her workers except a few. Does this come under discrimination or does this come under harassment and bullying? Again, not always super obvious. Again, workplaces are complicated. It can be more gray than we like. Situations are not always black and white and easy to see. So specifically with this one, the thing that gave me pause was that she treated some friends differently, and I thought that might affect it. But in the end, this would fall under harassment. That she is treating coworkers with inappropriate comments that they know are unwanted or unwelcome, and it's a repeated pattern. Might even be classified under bullying as well. But yes, this would fall under harassment. It's not under a protected ground. It's it would fall under harassment.
You could even go as far to describe the situation or example as a toxic work environment situation where she's creating a notion or culture of, aggressive notion, attitude, whatever it is, physical conflict with certain people, except for those who she has on a hierarchy of where she gives respect to and she treats kindly and she likes, and this can be changed for whoever the situation is about, but that supervisor particularly can be labeled as creating a toxic work environment, especially when they are the head, especially when they're the lead position, and controlling initially the culture of the work environment in itself. If you guys are having that kind of good flow, if everybody's being treated with respect, the idea that we're all valued equally, appreciated equally. So yeah, this is definitely an example of harassment and bullying, as Paul was saying, and can even go as far to say a toxic work environment.
Absolutely. Okay, so this will be our last little example, kind of solidify our knowledge. Ben, who is a transgender man, is a consistent top performer in his department. But Greg and Laura, who know he is transgender, feel that because the boss is a family friend of Ben, he is getting special treatment. Because of this, they start to make fun of Ben, leaving him mean notes on his desk, stealing some of his supplies, and on one occasion accused him of plagiarism. So again, this one's kind of a complicated one, kind of a gray one. again, I encourage people to, if you're comfortable, to give your thoughts in the chat. Obviously, no obligation, but yeah, just to guess even. So with this one in particular, it's hard to tell. This honestly could fall under both. It could fall under either one or the other. Because if they are being mean to Ben because he is transgender, that's a protected ground, that's discrimination. However, if they are being mean to him because he thinks that he's getting special treatment from the boss because there's maybe some nepotism there, a family friend, that would fall under harassment. But it's not super clear from this example if it falls under one or the other. It's a bit more on the gray side. That's what real life is like. Real life is going to be a bit blurry. A real life is going to be a bit complicated, and that's exactly what SWEAC is here for, to help sort out all of those kind of confusing nuances that the real world is just going to have. And this example is this case study is a good example of that. Okay, so you made it through. It was an hour. Got through. Hopefully, you learned something new. This is all of SWEAC's information to reach out and contact. Yeah, as a placement student, I have nothing but good things to say about TT and Scott and Mel. They've been fantastic. So absolutely, I encourage you to reach out to them for anything and everything. They've been fantastic. So yeah, but are there any questions? There was a question asked in the chat. TT, did you see that?